We are here again to discuss all these issues with you. As always, we have an esteemed panel of guests on the webinar today. Starting with, we have Ms. Anjali Agarwal, who is partner and head at Capital Market Services and at Corporate Professionals. That we have Mr. Manoj Kumar, partner and head M&A and Transactions, Corporate Professionals. Mr. Rishabh Singh, Senior Associate, Insolvency Resolution Services, Corporate Professionals. Mr. Ravi Prakash, Associate Partner, Securities Law and Corporate Litigation. And we have also a new member joining the webinar today, that is Ms. Priyansi Mittal, Associate at Corporate Affairs and Compliance Team. So I welcome you all to today's webinar, and I hope you will deliberate on all the changes that has happened since our last webinar previous month. And we hope the session will be fruitful for all those attending. We will also take questions. Some of them we have received already. If we receive during the course of the webinar, we'll take them at the end of the session when all the panelists are done on discussing their areas of topics covering the regulatory updates, and we will take the questions thereafter. So without wasting much of time, I'll now straightforward ask my team to put these slides on, and we move to discussing the changes in the regulatory aspect. And one by one, each of the panelists concerning their areas of concern or interest will discuss the relevant regulatory updates and share their views on the same. So team, can you put the presentation? So first one, I'll be happy to take, that's on Companies Act. It's a small but significant update. So post COVID, as you all know, we are having general meetings, both EGM and AGM, and even postal ballot through an e-vote, and where EGMs and general meetings are, EGMs and AGMs are heading through VC, and in postal ballot, we are only giving the facility to vote through e-voting through the entire period of 30 days instead of sending a physical ballot, and which has been from time to time extended by the Ministry of Corporate Affairs. And the last date was on ending on 30th September 2023, up till when you can use the facility to hold EGM, AGM through VC and postal ballot through e-voting. So this has now been further extended for a period of 1 year, till 30th September 2024. And till then, you can hold your AGMs, EGMs through VC in the similar manner in which you are holding since 2020. And similarly, postal ballot, you can also continue to only obtain the consent of or dissent of the shareholders on the resolutions by way of e-voting instead of sending them a physical ballot. So that's an update in the Companies Act. This is in line with what the Companies Law Committee has already recommended to make this as a permanent feature as part of the law. And I think as and when the Amendment Act will be tabled before the Parliament, this would be one of the amendment where for a class of companies, depending upon the amendment, this can be made as a permanent feature, and as and when they can be holding all their future meetings by VC. And this need of issuing circular for extending the requirement of holding EGM or AGM through VC will no more be required unless until the time the Act is amended in accordance with the suggestions made by the Companies Law Committee. Moving ahead, we'll take on the changes that have been introduced in REITs framework and InvIT framework. I'll ask Priyansi to take this forward.
Thank you, sir. I hope I'm audible.
Yes, you are.
Okay, good afternoon, everyone. So, Shivam, if you can just move to the next slide. So, in the month of August earlier, SEBI had amended the REIT and InvIT regulations, majorly focusing on empowering the unit holders. And one of those amendments was the introduction of the concept of unit holder nominee director, wherein an eligible unit holder, which has been defined as a unit holder holding not less than 10% of the total outstanding units of REIT and InvIT, they have been entitled to nominate a director on the board of the manager or investment manager of REIT InvITs. So this now the SEBI, by way of this circular dated 11 September, each for REIT and InvIT, they have outlined a detailed and comprehensive framework enabling such unit holders to exercise their board nomination rights. So if we just look at the key highlights of the circular, first is the formulation of policy. The manager or investment manager, they'll have to formulate a detailed policy setting out all the eligibility criteria, qualification criteria for such candidate, remuneration details, etc., which will be shared with the unit holders as well. Secondly, the managers and investment managers have been obligated to send a written intimation to all the unit holders, wherein they'll be informed of this right available and the process of nomination. Once initially this intimation is required to be sent on or before October 10th, wherein the eligibility will be considered basis the unit holding pattern as on September 30th, 2023. Moving after that, they will be required to send an annual intimation to the unit holders on or before April 10th, wherein the eligibility will be considered basis the unit holding pattern as on March 31st. So also the circular provides that in case a unit holder satisfies the eligibility criteria during a year, so they'll have to follow the annual nomination process. Moving forward, Shivam, if you can just move to the previous slide. Next is once such intimation is received by the unit holders, they'll see if they're eligible and if they intend to nominate a candidate. So they will be sending out a nomination notice within 10 days from receipt of such intimation from the managers. So wherein they will be required to mention few of the details of the candidate, which are described in the circular, like the brief profile of the candidate needs to be given along with the other details. So once that nomination notice is received by the managers, they need to evaluate the candidate basis the policy framed by them in this regard and the circular. If they find the candidate to be eligible, you can move to the next slide, please. If the candidate seems to be eligible and if he satisfies the criteria, then the managers will inform such unit holder and they will take steps to make their appointment on the board within 30 days from such confirmation. However, if the candidate does not satisfy the criteria, then they will send out the reasons in writing to them, and then the unit holder have an option to submit an alternative candidature. They can also nominate an alternative candidate. So there's also this point wherein the managers need to monthly review whether the unit holding criteria is still met by such unit holder or not. So in case they fail to meet such criteria, then such director has to resign or step down from the boards. Also, the circular provides that certain charter documents like the trust deed, re-trust deed, and the investment management agreement needs to be amended to include this specific clause within 6 months from the date of this circular. Also, the circular also sets out other conditions like vacation and cessation of such nominee director, and including other details. But three criteria which are relevant to highlight here is, if you can just move to next slide, please. So first is aggregating of unit holding. Such eligible unit holders are entitled to either individually nominate or they can also aggregate their unit holding and nominate such candidate. So in case they aggregate their unit holding, so such group wherein such unit holding has been aggregated, so they need to have an authorized representative. They can have up to maximum of 2 representatives. They will be the point of contact to which all the communication in the future will be made, with whom the communication will be made. Second is, if in case such eligible unit holder has such a right to nominate a director on the board of the manager or investment manager as a shareholder or lender of the manager or investment manager, then they will not be entitled to exercise such right in the capacity of an eligible unit holder under this circular, since they already have such right pursuant to some other arrangements. And lastly, the circular provides that such unit holder nominee director will refrain from voting on such matters wherein such unit holder director himself or his associates or the eligible unit holder who nominated such candidate or their associates are interested, since they will be deemed to be an interested party in that. So these are the key conditions among others which have been laid down in the circular, which needs to be met while nominating the candidate. So this can be seen as an important, significant move by SEBI towards empowering the unit holders and providing them a right where they can have a say in the management and decision-making power of the manager and Miss Manager of REITs or InvITs respectively.
Thank
So,
you.
over to
I'll now ask Shivam to move the slides, and we can discuss the amendments related to securities laws, specifically, though REITs is also securities law related to SEBI and ODR. I'll ask Anjali ma'am to take that forward.
Thank you, Ankit. I hope I'm audible.
Yes, you are.
Yeah. Shivam? Yeah. So a very important provision, a very important amendment which has been incorporated under the LODR regulations is with regard to the listing of subsequent issues of non-convertible securities. In the past, what we have noticed is that the company which has listed its non-convertible securities or non-convertible debt instruments, they were going in for listing for a particular set of the NCDs, but they were not going in for listing of the subsequent NCDs that they were issuing. So to barge the discretionary practices that were going on in the market, SEBI has mandated that any of the companies, any of the listed entities which have listed their non-convertible debt securities on or after 1st January 2024, whatever securities they list, the NCDs have to be listed on the stock exchanges. Likewise, as I said, there may be a situation wherein earlier NCDs were not listed on the exchanges. So in respect of those earlier securities, an option has been given to the companies that they may list such securities if they want to. It is not mandatory, but with effect from 1st January 2024, any NCDs or non-convertible instruments being issued have to be mandatorily listed for all the listed entities. Now, SEBI has prescribed a time frame within which this listing has to be done. So for all the companies which are proposing to come out with, all the listed entities which are proposing to come out with non-convertible debt securities on or after 1st January 2024, and they have any previously unlisted securities which have been issued after the January 2024 regime, have to be listed within a period of 3 months from the date of the original listing. However, there are 3 exceptions which have been provided by SEBI. Bonds which are issued under Section 54 EC of the Income Tax Act. We all know that 54 EC talks about the bonds which are issued to provide exemptions from the capital gains tax. If somebody has sold any property and they do not have any other investment mode, any other property wherein they want to invest the proceeds in, they can invest the proceeds in the bonds. There are various government agencies like REC, PFC, which keep on issuing these sort of bonds. So listing of those bonds is not mandatory. Then likewise, any non-convertible debt securities issued as a part of the agreement with any of the multilateral institutions, listing thereof is not mandatory. And any non-convertible debt instruments issued in compliance with the orders of any court or tribunal, even their listing is not mandatory. But with respect to the securities which I mentioned at point number 2 and point number 3 above, that is any NCDs, any non-convertible instruments issued pursuant to the court orders, or any of the instruments issued pursuant to any arrangements, they have to be held by the investors up till their maturity, and they have to be unencumbered. Likewise, for any of the instruments proposed to be listed, the key terms of such instruments are needed to be disclosed to the exchanges, which may include embedded options, security type kya hai us instrument ka, interest rate, charges, etc. are needed to be disclosed. Now, this is a big relaxation for the top 100 and top 250 companies, extension of timeline for verification of market rumors. We all know that with effect from 1st October 2023, and with effect from 1st April 24, top 100 and top 250 companies were mandatorily required to verify, confirm, or deny any of the market rumors that were prevailing with respect to the company. And a lot of buzz, ever since this amendment has come in, a lot of buzz was there in the markets and in the security in these listed entities arena, that as to how this compliance is needed to be done, how a particular company can keep a track of whatever rumors are going on in the market with respect to that entity. So there has been some relaxation granted with effect from 1st January 2024, top 100 companies, and then with effect from 1st August 2024, top 250 companies are needed to comply with this particular requirement. This will give a big say of relief to all these top 100 and top 250 companies as to develop a system within which they'll be in a position to be able to do a cross verification of whatever rumors are going on with respect to their entity, and then make according disclosures to the exchange. Again, pertaining to Regulation 30, there has been informal guidance by SEBI in the matter of GAIL India Limited, wherein the company asked that there are certain arbitration proceedings which are going on in the company, and is it needed to disclose to the exchange whatever arbitration proceedings are going on, because that would mean a contravention of Section 42A of the Arbitration and Reconciliation Act, which talks about not disclosing any of the proceedings, any arbitration proceedings, to any outside agency. So therein, SEBI has clarified that to whatever extent the disclosure is not in contradiction of any of the other acts, the same is needed to be disclosed. Although in the regulation as well, it is mentioned that to the extent permissible, we have to make the disclosure. So, but herein this thing has been clarified that to whatever extent we are not contradicting any of the provisions of any other act, the same is needed to be disclosed with. Shivam? SEBI has also clarified that disclosure may be to the extent the fact that the arbitration proceedings are going on, and whenever the arbitration award is issued, then it is needed to be disclosed, and the effect of the same on the listed entity. Likewise, their second query was, the regulation talks about the impact to be disclosed on a cumulative basis. What exactly does cumulative mean? Whether multiple litigations or cases with the same party are needed to be counted or needed to be aggregated. So SEBI has clarified that cumulative figure is needed to be arrived at by considering all the claims by or against a particular party in all the outstanding litigations. Meaning thereby, if I have raised a claim of 2 crore rupees against an entity, and it has issued a claim against me for 5 crore rupees. So the total amount cumulative would be 7 crore rupees. So it has to be done on considering all whatever by or against litigations are there. Now, with respect to the abridged prospectus, although in the equity segment, this abridged prospectus requirement has always been there, but with regard to the non-convertible securities, also the concept of abridged prospectus has been brought in. So with effect from any of the issues, public issues opening on or after 1st October 2023, the abridged prospectus is needed to be sent to all the investors, and the format has to be as defined by SEBI in their NCS regulations. This is the generation of QR codes. So a QR code is needed to be given even in the prospectus or abridged prospectus, pursuant to which the merchant banker or the QR code will be a convenient way for all the investors to access the full prospectus. So scanning of the QR code will be permissible, will be allowed. Nomination in the demat accounts. There was a circular wherein nomination was needed to be mandatorily given up till 30th September 2023. This provision, there were representations given to SEBI that there is a difficulty in giving nominations and KYC details for all the physical shareholders. So this date has been extended to 31st of December 2023. So all the physical shareholders have the last date for submission of PAN or nomination or contact details has been extended up to 31st December 2023. This again is a big say of relief for all the physical shareholders. Even if we look at many of the big companies as well, they have physical shareholders even as on date, which are either non-traceable or they have passed away or they have shifted their residences. So this step of providing PAN or nomination was in a direction to be able to trace them, and so that they are able to reap the benefits of their investments in the shares that they have invested in. But so considering the representations received from various stakeholders, this date has been extended to 31st December 2023. That's all from the securities market side. Over to you, Ankit.
Thank you, ma'am. I'll now ask Rishabh to share the changes. I think there are too many in the insolvency law. So up to you, Rishabh.
Thank you so much, sir. So today I'll be updating regarding the insolvency laws regulation, which has been recently amended. So coming to the first thing, that is enhancing the CIRP efficiency. So what we have seen in the past, that there were difficulties faced by the resolution professional or the interim resolution professional while taking control and custody of the asset. There were no prescribed format or guidelines to facilitate this process. But now what we have seen, that this IBBI has amended the regulation, CRP regulation, and has inserted certain regulation for this enhancing the CRP efficiency, like for the process of detailed procedure for custody and control of assets of the CD, and it needs to be recorded. So what we have seen, that the personals of the corporate debtor and its promoter or any other person who is associated with the erstwhile management of the corporate debtor, they are required to submit their details of assets to the interim resolution professional, which is under their custody. And apart from that, they also need to provide those details of the assets which are not in their custody, so that appropriate steps and action could be taken by interim resolution professional or resolution professional to curb that matter. Similarly, Regulation 2D has been inserted where these thing has been dealt, and assistance and cooperation by the personnel of the corporate debtor, that is Regulation 3A, where each and everything has been mentioned in details. Now coming to extended claim filing timeline and empowerment of RP and COC. So when this IBC was initiated in the year 2016, there were certain guidelines with respect to submission of the claim. The initial submission states that the CIRP claim should be submitted by the creditor within a period of 10-15 days after the public announcement. And if any of the creditor missed that timeline, they have the liberty to submit their claim till the approval of resolution plan. But later on, the same was amended, and it was held under Regulation 12 that the claim should be submitted within a period of 90 days. But as of now, what the current situation is, after the recent amendment on 28th of September, that the last date for filing of the claim should be up to the date of issue of the request of resolution plan under Regulation 36B, or 90 days from the insolvency commencement date. For example, if the RP is issuing a request for resolution plan on the 120th day, then the claim can be submitted on the 120th day for that. And if the RP is not accepting any sort of claim that is as per the law, then he should give proper reasoning that why such claim is not accepted, and why, and if he is accepting that claim, then he should also give reason that why such claim is being accepted. So next is empowering home buyers with enhanced role of authorized representative. So what the current law says that the RPs shall suggest a name of 3 authorized representative during the public announcement, and the financial creditor under the class, they can select their authorized representative to deal with their matter. So now the role of the authorized representative has also been increased. That is, they will need to review the minutes. They have to assist the creditor in modification of resolution plan, for submitting of various business opportunities, and so and so. So this has been included in Regulation 16A. That is after Regulation 3. Regulation 3A has been amended, where it has been the detail for same has been mentioned, and also the fee for the authorized representative. Like earlier, the fee was for the authorized representative for per meeting was somewhere like if the home buyer is in the quantity of 10 to 100, then rupees 10,000 should be paid to them for per meeting. Then 100 to 1,000 home buyer, the amount was 12,000, and for more than 1,000 it was 15,000. But now under sub-regulation 8, the number of creditors for 10 to 100, the fee for per meeting for the authorized representative is 30,000. 100 to 1,000, it's 40,000. And for more than 1,000 home buyers, the fee is rupees 50,000. So this has been done so that the home buyers earlier, which they have to face certain issues, now they are not prone to such kind of issue, and they are much more comfortable with the authorized representative duty, which is included in the regulation, and also more responsibility and further duty has been provided to the authorized representative under this regulation. And now the home buyers can also you can say that they can also replace the authorized representative, which was not earlier there. Then fourth point is audit of the corporate debtor to enhance transparency. So now what was earlier this situation was that the resolution professional, he was entitled to file application against the defaulting party, or not defaulting party, the parties involved in preferential transaction, undervalued transaction, fraudulent transaction, and extortionate transaction. That is 43, 50, 55, and 66. So now the committee members can request for the audit of the corporate debtor, and such cost will be part of the CRP expenses. Also, there has been streamlining procedural timelines. So, yes, sir.
Rishabh, just want to understand this requirement of audit earlier, because there were many cases where the RP initiates a forensic audit to look into the affairs, whether any fraud has been conducted by way of preferential transactions and others. So how this is different from that, and in earlier cases where these forensic audits were undertaken. So these were generally ordered by the COC, or it's the resolution profession that used to get it done at its own?
So, sir, earlier the situation was like that the resolution professional was supposed to make an opinion within the period of 75 days that the corporate debtor is engaged in some kind of POFE transactions or not. But now there was a strict timeline for that, that up to 75 days that opinion should have been made. And accordingly, the various CRP forms under CRP 1 to 7 was supposed to be filed. But now that power has been given to the COC member also, that if the resolution professional is not showing any interest, or is not having any motive to initiate such kind of audit against the corporate debtor, then the member can ask the resolution professional to initiate such kind of proceeding against the corporate debtor. That is the audit of the corporate debtor.
Okay.
So as we also know that the Honorable NCLT and Supreme Court, they have laid down various judgments where it has been stated that the CRP period, process should be conducted within a period of 330 days. But in many cases, the average CRP cases run for a year for somewhere around 300, above 400 days approximately. So streamlining of procedures for the timelines of CRP has also been amended in various things, that is including the issuance of information memorandum and request for resolution plan. Earlier, the scenario was that the resolution request for resolution plan should have been given within a period of 75 days, but now it has been increased to 100 days. Also, there is change in Form G, Form G that will enhance the value in the resolution plan. So what was the earlier situation that when this Form G was published, so we have seen that there were no very less participation from the public with respect to the resolution of the corporate debtor, because ultimately the aim of IBC is resolution rather liquidation. So now what has been done, the IBBI has amended Form G also, and there are certain columns which has been inserted in Form G. Right. So there have certain columns which has been included in Form G to provide more information to the prospective resolution applicants. That is the detail of the balance sheet and some portion of the information memorandum which were given to the interested resolution applicant at the later stage, that has now been given to them at the very initial stage, that is the publication, after the publication of Form G. So our next point is inclusion of COC minutes in the compliance certificate. So basically, when initially when this IBC was introduced, so at that time, resolution professional was supposed to give a certificate for the resolution plan. So there was no Form H, that is compliance certificate. That was introduced later after the 2018 amendment. So now what the amendment says, that the minutes of the committee of creditor, where the resolution plan was finally approved by the COC members, so that minutes of the meeting should be included in the compliance certificate, that is Form H, to help the adjudicating authority understand the COC decision rationale. Because generally what court generally seeks in the approval of resolution plan application, that what were the number of creditors involved, what were the total amount distributed, what was the voting percentage for the approval of resolution plan, so and so. So basically this particular amendment has been made to help the adjudicating authority, NCLT or NCLT in case, to better understanding for this resolution plan thing. The next point is streamlined debt assignment process. So this amendment says that creditors are required to provide details of debt assignment to the resolution professional within 7 days to facilitate COC meeting. So what we have seen that in many cases, the financial creditor or any of the other creditor, they assign their debt to any other person. Generally, we have seen that financial creditor, they assign their debt to the ARC, that is Asset Reconstruction Company. So in case of assignment of debt to any other party, that information should be provided with the RP within 7 days so that the COC meeting can be facilitated on the time. Next is detailed chronology and evidence submission. So this is with respect to submission of the application for initiation of CRP against the corporate debtor under section 7 or 9. So there was no prescribed, there was certain prescribed format, but now that has been streamlined, that the chronology of default limitation along with the evidence should be provided to the adjudicating authority so as to adjudicate certain cases.
Rishabh,
Yes, sir.
so in the changes, there were a lot of changes that were there in the regulation. So what were the key changes out of all of those which you've discussed, which have significant impact, and anything which still needs to be addressed?
So the major changes is with respect to the claim submission thing, because this amendment was made because ultimately there are heaps of pending cases before the tribunal with respect to submission of claim and acceptance of claim, because the court clearly stated earlier on that no claim can be entertained after the submission of 90 days. In the matter of ICICI versus Mobilox, it was held that if claim is accepted or submitted at a later stage, then it will ultimately lead to Hydra head popping. So this was the statement by the Honorable Supreme Court. So just to ease the process, now the submission of claim is valid till the publication of expression of interest, and even any claim is submitted after that period. So the RP has the liberty to bring that claim before the COC, and it's up to the COC to decide whether the claim can be admitted or not. Basically, they can discuss the implicity of that particular claim, that if we are going to accept this claim, then what will be the issues or repercussion for that.
Okay. You can carry on.
So now certain amendments has been made by IBBI with respect to Insolvency Professionals Regulation 2016. So in this, we have observed that unified enrollment and registration application. So a single application form has been introduced, enabling individuals to apply for both enrollment and registration process in one go. So earlier, what was the situation that if you want to enroll yourself as an insolvency professional, then you are supposed to pass the limited insolvency exam. And after passing of that limited insolvency program, you again need to do registration, that is within a period of 1 year from passing that exam for registration process. But now that thing has been simplified and only a single application form has been introduced for the ease of the process. The second is streamlining approval timeline. So before that, there was no timeline with respect to the enrollment and approval of registration or rejection of the approval. So now the amendment clearly specifies that within a period of 60 days for the approval of unified application for enrollment by the IPA, and 30 days period for the want of forwarding the unified application for registration to the board. So basically, we have seen that there is a time, now there has been a timeline which has been introduced for the ease of this process. So additional requirements for surrender or expulsion. So IPAs now have additional criteria to consider when accepting application for surrender of professional membership or expelling professional membership. These criteria include compliance with fee payment to the board, disciplinary orders from the IPA or board, regulatory filing and disclosure, record maintenance and transfer arrangements, and any other stipulated requirement under the code. So there was no prescribed format or forms or criteria for the surrender of professional membership. For example, if any member or insolvency professional is expelled by the board or any adverse order has been passed on account of disciplinary proceeding, So now this thing has been made simplified, that any person cannot simply go and surrender their membership. They need to undergo certain process. That is, they have submitted their fee to the board. Is there any disciplinary proceeding pending against that insolvency professional? And if there is any disciplinary action proceeding pending against that insolvency professional, then till that time, that person cannot surrender his insolvency certificate practice. And the fourth one is reduced timeline for registration. Like I was talking about that earlier on, there was certain timelines, but that were not specified. Now the timeline for approval of unified registration process, which has been recently incorporated, and that has been reduced to a period of 30 days and 60 days in terms of taking approval internally. Intimation and special procedures. So now IPAs are now required to inform the board in case such as acceptance of membership surrender, expulsion of members, demise or of an individual, winding up or dissolution of a company, LLP or registered partnership firm registered as IP. So now last year a special amendment was made that now the insolvency professional entity can also act as a insolvency professional. So basically before this, only certified or registered insolvency professional with the board, they were supposed to act as the insolvency professional. But after the amendment which came last year, it was clearly stipulated that the insolvency professional entity can also act as an insolvency professional, subject to that they are registered with the IBBI. So special procedure for that thing has been made, that if the particular insolvency professional or IPAs, they want to surrender their certificate, or by some disciplinary order, they have been expelled from the IPA entity or agency, or they want to wind up or dissolve their company. So they need to inform the board in that cases, and accordingly the procedures will be done, and accordingly the things will go on. The last is the F clause is surrender of certificate. So a provision has been introduced for insolvency professionals to surrender their certificate of registration to the board. So surrender of certificate, like I was talking about right now, that now any person cannot simply go and surrender his or her certificate. They need to go a certain procedures, like they need to certify that they certify or give a declaration that there has been no disciplinary action or proceeding going against them. They have duly submitted their fee, and they have complied with all the other rules and regulation present for the surrender of certificate.
Shivam, next slide.
So with respect to liquidator fee under regulation 4 subclause 2 subclause B of IBBI liquidation process. So this amendment was introduced on 28th of September last month. So with this respect, the clarification with respect to liquidator fee has been provided. So the key points of this clarification are that subregulation 1 and 1A of regulation 4 states that fee payable to the liquidator should be decided by the COC or the stakeholders consultation committee, depending on the circumstances. So what we have seen that during the last COC meeting under CIRP, where the COC members decides that okay, the company now cannot go for resolution. So ultimate, it can be sent to liquidation under section 30. So what happens that during the last COC meeting, the COC members unanimously decides to appoint the resolution professional as the liquidator, or they can appoint any other person to act as the liquidator, and accordingly the fee for the liquidator is decided. Or if that fee has not been decided, then the stakeholders consultation committee, that is after the commencement of liquidation, they can decide on the fee of the liquidator. Second is, if the liquidator fee is not determined under subregulation 1 and 1A, clause B of subregulation 2 of regulation 4 specifies that the liquidator shall be entitled to a fee as a percentage of the amount realized net of other liquidation cost and the amount distributed during the remaining period of liquidation. The exact fee calculation is provided in a specified table in the notification. So what happened that if the liquidator fee is not decided during the COC meeting or the stakeholders consultation committee meeting, then the liquidator is entitled to receive the fee as per the table which has been provided in the regulation. So what we have seen that, Shivam, next slide. So in essence, this clarification ensures that liquidator fee are determined in transparent manner. If the COC or SSC does not set the fee, a default fee structure based on the percentage of realized and distributed amount is applied as per specified table in the notification. This clarification aims to provide clarity and consistency in fee determination process during the liquidation of the assets. So what we have observed that on the first 1 crore in the first 6 months, that suppose if liquidation commencement date is on 1st of January, then in the first 6 months, if the liquidator is able to sell off the assets of the corporate debtor, then he is entitled for 5% of the total amount of the assets which he has sold. And further, if he is unable to sell the assets for like another 6 months, if he, for example, if he is able to sell the assets within a period of 12 months, then he is entitled to for a fee of somewhere around 3.75% for the total sale amount. So now that thing has been revised that but on the first 1 crore in the first 6 months, it's 5 CR. On the next 9 crore for the first 6 months, it's 3.75. And on the next 40 crore in the first 6 months, it's 2.80. So basically, this thing has been clarified by the amendment. So as there is no discrepancy regarding the fee thing among the liquidator. Next.
Rishabh, this change in the fees of the liquidator, is this the something which has been issue raised by the liquidators, or the regulator was itself apprised of the fact that there is some problem which is ongoing?
Yes, sir. So basically, there was some issue with respect to the realization of the assets, and what happened that the liquidator, after the selling of any assets, so what they used to do that once the fee is realized after selling of any asset, so for that amount which has for the amount which has been received by the liquidator by selling any asset, they can deduct their fee as per the table. And while distribution also, they were entitled to get some amount that is also prescribed in the table. So what liquidators generally do in this kind of thing, they certain assets of the corporate debtor, that is the bank balance or FDR line or stock or any liquid asset which is in the possession of the liquidator. So they simply deduct their fee as per the table from that, and while distributing the amount to the stakeholders, they also at that period of time, they generally deducted their fee. So now this clarification has been made that only you can be entitled for your fee only on the realization of assets which you have made efforts to sell and liquidate. they cannot simply liquidate the FDR from which is lying in the bank and simply deduct his fee as per the table. So this was the main bone of contention between the COC members and the liquidator, which resulted in amendment of this particular regulation.
Okay, but has this now solved the issue?
Yes, yes, sir.
Okay.
Now the law is very clear that you cannot deduct your liquidator fee from certain kind of assets of the corporate debtor until and unless you are going to realize it by selling or making efforts.
No, so for example, if I have to sell 100% of the assets, 80% have been, I have sold 80%. So can I take my proportionate share out of that 80%, or I have to wait till the 100% is sold off?
No, no. So what happens that in liquidation, we are aware that the assets is either being sold as a going concern. Initially, what happens that COC generally tries to sell the asset as a going concern. So if that thing fails, then the resolution, the liquidator can sell the assets of the corporate debtor in piecemeal. So as the assets of the corporate debtor is realized and sold, so liquidator can definitely take his share of the fee from that thing, because there is one regulation also which speaks that after the realization of amount, the amount should be distributed to the stakeholders within a period of 90 days. And if that thing has not been done, then certain interest should have been paid to the stakeholders for not distribution of money to them.
Okay. No, I think there were too many amendments last month.
Yeah. Yes. So recently, the MCA has exempted aircraft-related transactions from IBC. So basically, what happened? There was the Convention on International Interest in Mobile Equipment and the protocol specific to aircraft equipment established under International Civil Aviation Organization and the International Institute for Unification of Private Law in Cape Town on November 16, 2001. So India basically signed these agreement, and this amendment was signed on 31st March 2008. But till date, that amendment has not been enacted and enforced. So the central government of India, utilizing its power under IBC, they have issued notification that the aircraft engines or helicopter, basically aviation field, they will not be covered under that section 14(1) of the IBC. And the exemption of this thing, I think it's going to benefit the recent ongoing case of Go Air insolvency. Because what happened last time in Jet Air insolvency, the leased aircrafts were duly taken by the leaseholder, who were the actual owner of that engines. So now that thing has been, I think it will be a boon for this ongoing CRP proceeding. Since now the matter is before the Honorable Court, so it would be, I would not be in a position to express the exact thing on that particular thing.
No, but will this impact the ongoing Go Air issue, because the matter has already been submitted before the NCLT, and this notification has now come after the admission of the insolvency proceedings?
But the notification clearly says that it will have a retrospective effect. So this has been passed, and all the pending matter which is going on, so it will they will be benefited from this particular notification.
Okay. Request the Ravi to take this forward. Meanwhile, he is joining. Yeah, he's there.
Very good afternoon, sir.
Good afternoon.
So
thank you, sir.
I'll start with first this AIF circular, and thereafter we would move on to a judgment that has come in. It has become the talk of not only town but across the fraternity, industry, as well as legal professionals. So this circular, which changes the regulatory reporting mechanism by AIFs, is it's not the first in the row, but the developments started back in 2013 when several timelines for AIFs to report their activities were envisaged and prescribed. With time, AIF industry took up, and I think in terms of performance, although mutual funds are fairly old concept, AIF, although new, is performing better than expected because of being privately pooled and having flexibility. With such flexibility, some concerns also arose. As we have seen recently, there are issues intersect between the investors of AIF and on the transparency and disclosure. So therefore, an attempt has been made to streamline the reporting requirements. So this new circular, calls for a trial run for June 2023 quarter by all the AIFs, and SEBI has asked AIF associations to sensitize the AIFs to run this trial and test it on the basis how it goes. Then the quarterly reporting deadline, which earlier was 10 days, it has been increased. It has been made 15 calendar days, so that clarity has been brought in. And the third change that this circular brings is that all this quarterly reports has to be submitted on the SEBI intermediary portal within 15 days of each quarter end, and that is calendar day as clarified. As I said, the trial run would be ensured by all the associations and AIFs, and this has to be submitted in a revised format. Whatever the developments or activities of trial run is concerned, they have to submit it by October 15, 2023 on the intermediary portal, which is also called SI portal. The report for quarter ending September 30th, 2023. This is also revised format has been prescribed, enhancing the disclosures, both qualitatively and quantitatively. And this has to go by 15th of November. And from quarter ending December 31st, 2023, all the AIFs will submit report going forward in the revised format. So there is clearly a transitioning period provided. In terms of reporting formats as well as timelines, there are changes. Apart from that, there are no major changes that has been brought to AIF. This industry and these privately pooled vehicles continue to run with the required flexibility, and which provides them the required nimbleness also. Now moving on to Shivam, can you help with the slides? Yes. So now moving on to the case of Dr. Pranay Roy versus SEBI and BSE and Radhika Roy, along with other individuals and officials of NDTV. A seminal judgment has been rendered by SAT yesterday. It was pronounced yesterday, but was reserved long back on 22nd of September.
Ravi?
Yes, sir.
I think Shivam needs to move the slide.
Yes.
Shivam, please.
I think that's all. I think there are only 2 slides on this. This judgment is not covered in the slide.
Okay.
Yes. So this judgment was reserved on 22nd of September and was pronounced yesterday. The judgment brings much required clarity on certain aspects, which I'll be covering. I'll keep it brief because the judgment is out and it is available for the readers to go through and understand. I'll just give you highlights of the judgment. So what happened is that there was an investigation pertaining to 2006 to 2008, wherein charges of insider trading were alleged on the ex-promoters of NDTV, Dr. Pranay Roy and Radhika Roy, and also some officials and consultants of associated with NDTV. The issue was that these people acted opportunistically and they scavenged on the UPSI or the price sensitive information for making their own profits at the cost of market integrity. So this matter was taken up only in 2018, surprisingly on the complaints forwarded by NDTV itself. Basically, it was a crisscross firing in which all these people got caught up. A complaint was initially filed with respect to certain group of individuals. They filed some complaints, and that is how the investigation was taken up. Ultimately, ex-promoters as well as the initial suspects, both were involved and taken into the ambit of investigation. In 2020, full-time member of SEBI passed an order leveling the charges of insider trading and banning the ex-promoters, as well as imposing a direction of disgorging the ill-gotten gains, more than 16 crore rupees. It was this order which was challenged before SAT, and the ground of challenges were this. One of the ground was that there is an inordinate delay in taking up the matter, because the offense pertains to year 2007 and 2008. Between September 2007 to April 2008, the tradings were done, and the matter was only taken up in 2018 for the first time, despite the fact that the complaints were moved by NDTV much prior to 2018. So this was one of the aspects. The second aspect, perhaps more nuanced and more useful for us to consider, was that how do you determine a price sensitive information or the fact that a UPSI is in existence? Well, the issue was argued at length, but I think the tribunal found a smarter way to decide on the issue, not going into a lot of principle-based approach. They applied a logical mind, and in the allegation there were 6 UPSIs that were alleged. They called it PSI 1, 2, 3, consecutively up till PSI 6. And all these UPSI were of different natures and colors. So PSI 1 was regarding the expansion of company. PSI 2 was a strategic alliance with Karan Johar and Dharma Productions. And PSI similarly 3 and 4 were also regarding some extraordinary developments that could have bearing on material bearing on the prices of the scrip. 5th was signing of an agreement with NBC Universal. It's a foreign company which was going to acquire the non-news segment of NDTV. Now this PSI 6, which is the contentious one and on which most of the matter was fought, was about board's decision to evaluate options for reorganization of the company, which could include demerger, split of the company into news-related business and investments and beyond news businesses, which are currently held through its subsidiary NDTV Networks PLC. So it was a decision of the board to evaluate further for the options that will be taken and implemented. There was no implementable decision. It was only an evaluation decision that was taken. This was considered to be a UPSI, and within this bracket, the charge was on ex-promoters to have dealt with the shares of NDTV. Now, SAT, on examination of this UPSI 6, remarked that this can't be a UPSI, going by the regulations and statutory definition of UPSI. Howsoever broad it is, it cannot ever encompass merely a decision to evaluate, because there is no finality. There is no definite decision which way the company is going to go. The board might very well take up the issue for evaluation and say that we would like to move ahead in the status quo, things as it is. So the SAT gave these reasoning and said, because there is no definite decision, it is only evaluation, this is not UPSI, and this dropped the charges. Because these were multiple appeals arising from a common investigation and common set of facts. Although the charges were different, the roles played by individuals were different because, but all the individuals and entities those were dealing into the script were categorized into one of these UPSIs, that is between 1 to 6. So all those who were charged based on UPSI 6, their cases were dropped because this was not considered to be a UPSI. For others who were charged with dealing in the other set of UPSIs, SAT had decided in one of the appeals arising from the same matter, which was the appeal of Quantum Securities preferred in 2021, that the issue of inordinate delay and whether their trades were motivated by UPSI were not dealt by the whole-time member of SEBI. What I mean by this is, although the notices took ground of delay, as well as the fact that they were not, their trades were not based on the UPSI or were not motivated by the opportunistic behavior of misusing the UPSI, these two contours of their arguments were not considered by the whole-time member, and no reason was given out in the order to deal with these submissions of the notices. And therefore, SAT remarked, by referring to the decision rendered by SAT in 2019 in Abhijit Rajan's case, which later on got confirmed from Supreme Court, that misuse of UPSI, the opportunistic behavior, and the circumstantial evidences which would indicate on that someone was trying to scavenge on the UPSI is necessary. And unless that is established, merely because there was a UPSI, the regulator cannot run havoc on each and everyone who traded during that period. Meaning thereby that it is necessary for the regulator to establish a nexus between the trading and the misuse of UPSI, even though circumstantially, but the theory or the hypothesis should build a nexus between the two. It can't be a plain simpliciter statement that there is a UPSI, you have traded, and therefore it's an insider trading. Because the exceptions are also laid down in the regulations. So far as the insider trading is concerned, it is laid down in the regulations itself. So therefore, referring to Abhijit Rajan's principles laid down by Supreme Court and before that by SAT itself, SAT said that we would again remand back these matters. So for UPSI 6, which was for this evaluation, they quashed the order completely. And for the other charges, they said because the inordinate delay issue has not been dealt with, and it is also not dealt with whether PSI and its misuse by these entities and notices were reasonably considered. So therefore, they said we are remanding it back in terms of their recommendations given in Quantum Securities. Those recommendations obviously were that regulator will pass reasoned orders dealing with the submissions of the notices on all the aspects. So one takeaway and two key takeaways from this order is that the principles laid down by Supreme Court in Abhijit Rajan's case, which was the case of Gammon, those principles are crucial for the regulator to allege, level, and examine the charges of insider trading. And second, it is also incumbent for SEBI that whenever they are fraught with a situation where they have to pass an order, they must deal with the issues raised by the notices in their defense. I think these are the two key takeaways from this order, and it certainly goes a long way forward in bringing certainty so far as the enforcement of insider trading laws are concerned. Although it is going to make the path tougher for SEBI to establish, and it might also provide unnecessary incentives to those who are ingenuous enough to plan it in a very immaculate way so that they are not caught and no traces are left behind. And we'll figure out going forward what jurisprudence develops on this on this front.
Thank you, Ravi, for throwing light on this important case law. We have received a couple of questions. Rishabh, there is a question on IPs who have attained 70 years of age. Are you there?
Yes, sir.
So there is a question by Mr. Ghanshyam Kaushik. That is, what is the amendment for IPs who have attained 70 years of age on following points? First is whether it is mandatory to pay membership fees to IPA for maintaining IBPI registration.
Sir, I think that is mandatory because up to the age of earlier, the court stated that till the age of 60 years, the IP needs to pay that fee for registration and renewal of membership. But after that, also the process is still the same. The fee has definitely been reduced, but a certain amount needs to be paid to the board. And also out of the profit of which insolvency professional is earning, so he also needs to pay a certain portion of his profit to the board.
Okay. Another is whether such IPs can take up insolvency related work, support work without the requirement of AFA
That is
to
authorization.
AFA to IPRE, PFCU,
With
COD, insolvency course
right.
training, etc.
Whether compliances like half-yearly statement is
I'm
required to be
talking about the
submitted.
third question first.
Sorry, sir?
Third question.
Third, okay, whether such IPs can take up insolvency related work, support work without requirement of AFA. So for taking any insolvency work, that is any CIRP assignment or liquidation assignment, a resolution professional or insolvency professional must have this authorization for assignment certificate, because in many cases we have seen that the authorization for assignment has been expired, and the honorable NCLT and the board, they have allowed the insolvency professional to only entertain that matter and to conduct the CRP and liquidation process in those matter where the AFA was valid during the time of taking that particular assignment. But where the assignment has not been commenced, or the CRP or liquidation has not been commenced, and the AFA is not valid, with not valid AFA is available with the insolvency professional, then such insolvency professional cannot take assignment without having that.
Okay. And the second question, half-yearly statement.
Yes, whether compliance like half-yearly statement is required to be submitted even when no AFA is allowed, no insolvency liquidation work is performed. So yes, nil statement is to be filed, but yes, half-yearly statement is to be filed, that whether the insolvency professional is having any sort of assignment, undergoing assignment or pending assignment under his belt. So half-yearly statement needs to be filed. It's there are three options available there, that yes, no, and not applicable. So he can simply select no, not applicable, and he can submit that thing.
Okay, thank you so much.
Welcome.
Ma'am, you are there. A couple of questions.
Yeah, I'm there.
First is, I think both are related. Is this correct that RTA is not required to maintain share transfer deeds beyond 8 years? Is there any master circular dated 17 May 2023 addressed to all RTAs to this effect?
With regard to RTAs, there is a master circular. I don't know whether it's May 23 or June 23. There is a master circular, and the physical share certificates that are received for the purpose of transfer are needed to be kept for a period of 8 years. But the transfer deeds, whether they are a permanent document or can be removed after 8 years, as far as I understand, I know transfer deeds are a permanent document and are needed to be kept by the registrars for permanent time. So maybe some RTA can better give clarity on this provision.
We'll try to get some clarity and then revert on.
Yeah.
Really. Another is that if a shareholder disputes register of members as old as 25 years, 15 years, where company is contesting his contention that shares have been transferred, can he demand transfer deeds of those years from the company?
So, if I've understood the query correct, there is a dispute between two people.
Appears
One
like
is
that.
saying that the shares have been transferred
Hmm.
to me 25 years back.
No, I think the issue is company is saying that the shares have been transferred.
Okay.
But person is contesting that transfer and he wants the company to give him the transfer deeds.
I doubt it. Again, it's a question of 8 years only. If at all any documents are to be kept for 8 years, beyond that, nothing would be available.
I can recall we look into it. If the register of members and relevant documents have to be kept permanently, there is no. I will check whether any specific timelines are there for this keeping it transfer deeds for 8 years. So I think we look into the matter if there is a requirement. Maintaining the year after 8 years, I think in that case he can still request to company to just to evidence that the transfer took place.
Yes.
Okay, I think there are no other queries others relevant to this only. So I think we have no more queries. I believe thank you everyone for joining us today. Thank you all the panelists for taking your individual subjects. And we'll see you next week, same time on 149th webinar. And that's going on an important topic of importance of ESG integration in business studies. So how ESG, the buzzword, where people more understand it in terms of a compliance related subject, but how ESG can really, if effectively implemented, can also be an important part of the business strategy. So we'll discuss this in the next webinar. And till then, please do take care and thank you everyone for joining in. Thank you all the panelists.